Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Indonesian salvage law within the framework of contemporary maritime law. Indonesia is located at a crossroad position or posisi silang that is between two land masses of the world, Australia and Asia, and between two great waters of the Indian and the Pacific Oceans. It is also a place where straits used for international navigation are located. Such strategic location of Indonesia has made Indonesia as a center of international trade routes. The correlation between international trades and transportation is obvious since without transportation, international trades cannot be conducted. Although there are at least six modes of transportation, ocean transportation is somehow still preferable, while time utility and cost utility are two important factors in determining which modes of transportation will be used. Ocean transportation offers high capacity and quality. In addition to this, although the fixed cost is quite high, variable cost is extremely low. Thus, 90% of international trades are carried out through the oceans. Since Indonesia's waters can be considered as a shortcut for international trades from the south going to north and vice versa, crowded ocean traffic often occurs in Indonesia. While this might bring advantage for Indonesia, especially related to economic factor, it is also cause problems as crowded ocean traffic often lead to sea accidents fire, such as collision, fire, grounding, and any other similar accident. In addition to this, unpredictable weather condition is also contributed to sea accident. Therefore, for parties involved in international trade using ocean transportation, it is crucial to assure that the activities in carrying goods across the ocean are incident-free. However, if an accident happens, assistance from professionals to preserve items of property is desirable. In such, salvage law emerged. This study analyzes comprehensively Indonesian salvage law within the framework of contemporary maritime law, while contemporary international salvage law adopts wider and more balanced approach in both commercial and environmental aspects. Indonesian salvage law still focuses narrowly on the value of salvage property as the primary measures of success. The origin of maritime law and its scope, as with many other aspects of law, it is difficult to make a precise definition and to draw exact lines as to what falls within the definition one decides on and what falls outside. Maritime law emerged from the need of maritime states in having universal international regulation concerning the operation of ships and all of its legal implications arising from it. Thus, it is submitted that the existence of maritime law have been shaped by practical needs rather than by pure academic activities. Therefore, it develops rapidly, although from its very beginning maritime law has been international and national maritime law is usually the implementation of international maritime law in national sphere. In fact, historical international maritime law was rooted from British law. As one of developed states having many colonies, United Kingdom often transport raw materials from its colony states to United Kingdom through the ocean by ships. During the process, porting regulations were formulated. Even until nowadays, such regulations are still implemented during the carriage of goods by sea. Although there is no official definition of maritime law, but it can be described as the set of legal rules, concepts, and process that relates to navigation and process by water. Traditionally, the focus of the law is the ship and the legal incident that arise from its operations, which are plentiful. Since international trade involves the movement of goods across the countries, each having different legal rules, parties in international trade needs uniform regulations setting up legal rules, concept and process that relates to navigation and process by water. This is what maritime law is all about. It focuses on ships and legal incidents arising from its operation. Maritime law includes two aspects, public and private law. The example of private aspect of maritime laws include when there is a dispute involving a breach of contract from the one party within carriage of goods agreement, the responsibility of carrier and also the rights and obligation of parties involving in the process of carriage of goods by sea. On the other hand, the public aspect of maritime law includes when it deals with ship registration, the management of ship crew, safety of ship, and other things relating to the interests of states such as marine environment. Salvage is one of maritime law's scope having both aspects, private and public. Private aspect of salvage is when it deals with proportionality of salvage reward and marine insurance, whereas public aspect of salvage is when it involves the mechanism of salvage itself. Indonesian maritime law, since it is argued that national maritime law is mostly the implementation of international maritime law, therefore, the practice of maritime law all over the world should be similar, although not identical. However, in Indonesia, maritime law is termed as private law of the sea and included within the scope of Indonesian commercial law system, while Indonesian commercial laws is the form of lex specialis of Indonesian private law. Purwosucipto further argued that Indonesian commercial law can be defined as law of obligation which arises from company related laws. Thus, it is argued that it is insufficient to put maritime law within the scope of Indonesian commercial law. This is because the origin of maritime law is international law, and once more it should be remembered that national maritime law is the implementation of international maritime law, whereas commercial law and private law are laws that developed originally within the scope of national law. Thus, it is not surprisingly that maritime law in Indonesia did not develop in accordance with international development in in the same subject matter. Indonesia maritime law is provided within the Wetboek van Koophandel, or known as Kitab Undang-Undang Hukum Dagang, or KUHD. KUHD was adopted from the Netherlands law and come into force in Indonesia since April 1938 by the Declaration of S 1933 until 1947 GIS 38 1 and 2. This rule has been out of date with respect to some of its provisions. For instance, provision regarding collision, Article 534 and 544 AKUHD state that collision includes collision between ship and between ship and other object. Meanwhile, Rule 1 of the Collision Regulation 1972, which has amended representatively in 1981, 1987, 1989, 1993, and 2001, reads, "The rules apply to all vessels upon the high seas and all waters connected to the high seas and navigable by sea-going vessels." Or in other words, collision only includes collision between ship and other objects, so-called allisions, does not include within the definition of collision envisaged within the Collision Regulation 1972. The amount and currency state for limitation of liability. The amount and currency state for limitation of liability has been out of date and not suitable with current economic condition. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.